had left to learn about this, and I learned a lot from Professor Garrett's book. So I am particularly excited for him to be speaking to us tonight. Brandon Garrett is the L. Neil Williams Jr. Inaugural L. Neil Williams Jr. Professor of Law at Duke University. He was formerly at the University of Virginia as a professor of law. His interests are in forensic science, in the criminal justice system generally, and eyewitness identification. One of my favorite subjects, habeas corpus, and innocence in the criminal justice system. He's written books on all of those subjects and many, many, many law review articles. And, you know, it's remarkable that he is a Duke law professor because he's so poorly educated, having a bachelor's degree from Yale University and a law degree from Columbia Law School. So it is really a pleasure to introduce you to Professor Brandon Garrett. I will ask everyone to make sure that you stay unmuted, and then hopefully he will be kind enough to take some questions at the end of this, at the end of his talk. So Professor Garrett, thanks for being with us.
Thanks for having me. And after those Duke cracks, I changed my Zoom background to make it a Duke background and not a Durham background. But I've been teaching here at Duke for just a little over 2 years, and it's been a wonderful new home. I certainly did finish this book, End of Its Rope, while I was at the University of Virginia. Harvard Press published the book. It's called End of Its Rope. It was written during a time when I think the national mood was much more optimistic than it is now. And that said, the trends that I talk about in the book in terms of like the inexorable decline of American death sentencing continue to this day, despite the national push with Attorney General Barr and the President Trump to conduct more federal executions, despite some very tough on crime rhetoric at the national level, at the local level, at the state level, we still see death sentences declining. And, you know, when I was a law student, something that I think about now that I'm a law professor and I subject my students to the same kind of hopefully different educational methods, but I'm teaching habeas corpus just like I took the course in law school. I think I try to place myself when I'm teaching my students in the shoes of myself as a law student. But when I was a law student in 1999, 2010, the death penalty was in a very different place. The Anti-Terrorism and Effective Death Penalty Act had just been enacted only a couple of years before. You know, starting in 1997, it was applying to capital cases and just federal habeas cases generally. I worked in law school for Jim Liebman and Jeff Fagan and Valerie West as they were doing their big broken system study of death sentencing. And the entire point of that study was to describe how death sentences had just shot upwards. They'd exploded in the country. But first, in reaction to the Supreme Court in Furman versus Georgia, striking down all of the death penalty statutes across the country, finding them unconstitutional under the Eighth Amendment. And in the 1970s, states certainly like North Carolina, like Virginia, where I used to live, just went wild with death sentencing to show that they really cared about the death penalty. And then the Supreme Court reconstitutionalizes the death penalty, says that there's some ways of making it work under the Constitution. And then in the 1980s and 90s, death sentencing continues to rise and rise. I was not thinking when I was a law student, 1999, 2000, that the American death penalty had reached an inflection point and it would be all downhill. There would be steady decline from that point on. No one was thinking that. None of the professors I was working on, they were studying how the death penalty was being overproduced and how abusive it was, how there were wrongful convictions, how it bore little relationship to wrongdoing, the poor quality of the defense lawyering, the race disparities in death sentencing. And no one was talking then about how it's all about to slide away. And so the End of Its Rope book is documenting not the rise in death sentencing, but why is it that it has continued to slide away in this consistent way? If it's okay, I do have some images that I could show on slides. Let's see if I can, it looks like I have screen sharing power. I don't know. So if I could be co-host for a little bit, I could show some of the graphics from the book.
I think you should. I think you should be able to now.
Great. Okay. Yes. Okay. So my head will get smaller and the graphics will get bigger, but I'll turn the screen sharing off. I'll do a little bit of both. There's the title of the book, End of Its Rope: How Killing the Death Penalty Can Revive Criminal Justice. And I guess what is atypical about the book is that it's a death penalty book, and it's also not about the death penalty. So some of what I talk about in that book is about bringing justice back to our criminal legal system, and how the weight of the death penalty has distorted our system, how lifting that weight can create more opportunities for reform. So that's part of the tenor of the book as well. Maybe a little over optimistic to be looking at what happens to our system once the death penalty is gone. But then again, in many states, even if the death penalty is on the books, the death penalty is gone in practice in many respects. Just to introduce myself a little bit, I've been busy since I've been at Duke. We actually just 2 weeks ago launched a new center that I head at Duke called the Wilson Center for Science and Justice. And we do lots of different research, including on criminal sentencing, plea bargaining, bail reform, a lot of work relating to wrongful convictions, eyewitness error, forensic error, how to prevent false confessions. And so I feel like the luckiest person ever. I have a research lab, incredible postdocs doing work with me, incredible scientists. It's an interdisciplinary center where a lot of what we do is empirical research. We also do amicus briefs, though. At our launch event, one of our students helped to work on an amicus brief in a Texas case involving blood spatter evidence. And Joe Bryan was just released earlier this year. And the reporter, Pam Koloff, who highlighted how unreliable the evidence was in the series called Blood Will Tell, spoke. So it's an amazing event. And I feel very fortunate to now have grant support to keep the center around for years and years. One of the things we focus on, basically the center is focusing on all the themes that I talk about in the End of Its Rope book. In the End of Its Rope book, I talk about wrongful convictions and death penalty cases, and that's a big focus of my research. We do a lot of work on how evidence goes wrong. In death penalty cases, by their nature, these are murder cases, and one challenge in murder cases is that unless the person was caught in the act, the person who saw what happened may be dead. And so there's a lot of investment in forensics, but there may not be firsthand accounts of what happened. So some murders really are genuinely difficult to solve. There are low clearance rates for some murders. And that, combined with the pressure to solve homicides, creates a real risk of wrongful convictions. The second area of focus of my center is equity in criminal outcomes, including studying race disparities and arbitrariness. The death penalty is the area in the American criminal legal system where some of the most work has been done to study race disparities, arbitrariness, including because there's a constitutional element to it. A third area that my center focuses on is on behavioral health needs, particularly mental health, substance abuse, often the combination of the two. And again, the death penalty is Exhibit A. So many of the people on our death rows have severe, severe mental illness. So many of the people who commit the murders that are deemed by prosecutors to be the worst of the worst are people who are some of the least blameworthy because they have such severe mental illness. So here's the title of the book and the book cover. It's kind of a cheerful, springy cover. I don't know exactly what the publisher was thinking, but if you're interested, though, in looking at some of the underlying data that I collected, this resource website is a interactive website where you can look at death sentencing patterns across the country by county. And it doesn't work on my PowerPoint, but there's like a slider. You can look at how these patterns change over time. And I'll talk a little bit today. I'll basically be giving you a tour of this map to talk about why death sentencing has retreated in the way that it has. So here's a different way of looking at it. I was describing before how states went wild with death sentencing after Furman versus Georgia, after 1973. There's this huge spike in death sentences. A lot of the Southern Death Belt states just wanted to show how much they cared about the death penalty. We're not going to let the Supreme Court take it away from us. Backlash. But then in the late 70s, when the Supreme Court reconstitutionalizes American death sentencing, there's just a steady rise in death sentences up through the 90s. And then right around when I was in law school, late 90s, death sentencing goes into a free fall. And so that was the puzzle. Like, why would it go down? Like, the law didn't change. The Supreme Court didn't do anything nasty to the death penalty to take away its support. A couple of important decisions, but nothing that would account for death sentencing to free fall in that way. Public support for the death penalty has gone down modestly over the years, but still there's like a, especially in the pro-death penalty states, very strong public support for the death penalty. What could explain this? Crime rates have gone down, but we don't have a chart that looks like this in terms of incarceration. Despite all the efforts to try to reduce reliance on incarceration in this country, there have been very modest declines to our prison and jail populations. And whereas this death penalty, death sentencing had almost disappeared by the late 60s. It comes back in a big way, goes way up, and then goes way down again. Like, this is unusual. This is not like what is happening elsewhere in our criminal legal system. So on the data collection piece of this, I worked in law school on the broken system study. They were basically studying the rise, 1973 through the early 1990s. My friend Robert Smith did great work collecting data, looking at kind of the mid-2000s and then a number of years after that. And it was actually Rob Smith who came to me and said, basically, Brandon, you're a glutton for punishment. Someone needs to collect the bulk of the data on the rise of the death penalty. Like 2004 to 2009, there weren't that many death sentences by then. It was well into the decline. What we really need is like 1990 through 2004. Those years need to be filled in, and some of the recent years. But we need information on death sentencing every year to fill in this picture to understand the decline. And I thought that sounded like a fascinating project to kind of bookend the work that I had done as a law student. And it's just embarrassing as a person who cares about understanding our criminal system that we don't even have good information about who are the people sentenced to death every year. You'd think, like, we have information about certain crime rates. Really, there isn't just a list of who is sentenced to death in each year, who is resentenced to death in each year. There are death row rosters in this country, but people come and go from death row. The NAACP, a legal defense fund, has quarterly reports on who's on death row. Those were useful in this work. The Bureau of Justice Statistics keeps track of how many people are sentenced to death in each year. But to look at the details of these cases, what are the person's races? What counties were they sentenced to death in? Was it their first death sentence? Were they resentenced? All this stuff. It just didn't exist. It took Jim Liebman and Jeff Fagan and Valerie Rest years and years to track those cases through the 1970s through the 90s. And I decided, with the help of a lot of students, to try to take on filling in this gap in between. And so it was almost 5,000 death sentences that we ended up coding information on. Even more cases where someone had a second trial and were resentenced again. And in the mid-90s, you had hundreds of death sentences in a year. 300, 330, 340. A small number of these people, in terms of the number of death sentences, have been executed. Most people who are sentenced to death are never executed. And again, all this information is on this website. We had good information about defendant race. Trying to code victim race was very challenging. It's not always easy to know that information. And turning back to the county map, one of the things that really stood out, and if you play with the slider on this website that I created, especially if you focus in on a particular state, if you look at Pennsylvania, if you look at Virginia, if you look at North Carolina, if you look at Texas, you move the slider and you see that starting in the end of the 90s into the 2000s, the rural counties just disappear. They all just fall off the map. And many fewer counties in general are routinely sentencing anyone to death in a given year. And I used to teach at the University of Virginia. There are small counties in Virginia that you have never heard of that would just regularly sentence someone to death. Maybe not every year, but maybe every other year. That just ends. Same thing in Texas. The rural Texas death penalty just fades away. And Texas, Virginia, North Carolina, these are some of the top death sentencing states in the country. And you know, one of the mysteries that I wanted to unpack in this book is why? Why would this happen? You know, you think of the death penalty as being particularly popular in conservative rural counties, where there may not be as many murders, but people feel very strongly that retribution must occur. And yet it's those rural counties where the death penalty disappears. We don't think of the death penalty as a luxury suburban good, but that's what it becomes. Here's a word cloud just to show this in a different way, that the death penalty retreats to these larger counties. Los Angeles, Riverside County, California, Harris County, Texas, although in the last few years there have not been death sentences in Harris County. Philadelphia and Pennsylvania, although again, Philadelphia, same thing. It used to be a leading death penalty county, not so much anymore. Maricopa County in Arizona. There is this handful of counties that dominate death sentencing. And so, you know, we think of death penalty states and non-death penalty states, but really increasingly in the states that have the death penalty on the books, it's just a handful of counties, even in those states, that are routinely imposing death sentences. The New York Times did a really nice story using some of the data that I collected with some fancy illustrations and just highlighting some of these counties. Los Angeles, you know, Jefferson County, Alabama, Riverside, California, quite a few California counties, Pinellas County, Florida, and showing just how unusual these patterns were, that the scattered group of counties were accounting for so much of the death penalty in the United States. So before going back to counties, one of the analyses I did was to look at when did states create an office to handle capital representation at death penalty trials. And some states did it early on. When New York brought back the death penalty, it's not on this graphic because this is 2013, but in the 90s, when Governor Pataki brings back the death penalty in New York, well, obviously the lawmakers did too, but they were going to do it right. New York was going to show the country that you can have the death penalty and it'll be fair. And they created a capital defender office to handle and coordinate capital trials around the state. Very few death sentences resulted, and they ended that experiment after some time. Where I used to live in Virginia and where I now live in North Carolina, both states, North Carolina is a little bit earlier, around 2000, 2001. Virginia is a few years later, 2004, but the offices took a little time to start taking cases. Both North Carolina and Virginia created offices to handle death penalty trials. And one of the most powerful effects that I saw was this linkage between a state having some central function handling capital trials and the number of death sentences. The states today where some of the most death sentences occur are states where there is no function like that. And what that means is that there may be court-appointed lawyers that have limited experience. And most important, it means that there isn't an office. There isn't an office where you can have a social worker on staff, a mitigation investigator on staff. Certainly in Virginia, where I used to live, these capital defenders offices were a cost savings measure in part. It's a lot cheaper to have an office. And so you don't have a court-appointed lawyer who has to hire everyone to create a team. And it can take 6 months to a year to do that. And you're hunting around to hire an investigator, you're paying consultants. If you have an office, you have a paralegal on staff, you have a social worker on staff. It's much less expensive, but it's also much more effective. It means that you can start work on a case right away. And so we certainly saw this in states like Virginia and Texas, where there's now a collection of the rural counties all share a capital defender's office. And they don't have great resources, but one thing they can do is they can start working on a case right away. And that means they can start interviewing their client and collecting mitigation information. They may not get great discovery right away. They may not get much from the prosecutors, but they have access to their client. And I did a really detailed study of what happened in Virginia. I was able to order copies of trial transcripts from capital trials in Virginia. I was able to get every capital trial after these regional capital defenders offices were created in the early 2000s, and a big archive, but not everything, of capital trials from the 90s. And one thing you see is that once these offices come into effect and you have these 4 capital defense offices just handling all of the capital cases at trial, or if they plea bargain, that there are many fewer death sentences. But the result at these trials was also remarkable. Once these offices get created, more often than not, the result at a capital sentencing hearing was life and not death. When cases went to trial, prosecutors lost more often than they won. And then starting, well, about 8 years ago now, we haven't had a death sentence in Virginia. It hasn't happened. The few times that prosecutors have tried, they've lost. And to some extent, they've stopped trying so much. There's still plenty of cases that are capitally charged. They have all pled out. And so in Virginia, you have the death penalty on the books, but there's, is it 2 people or 1 person left on death row? And there have been no new death sentences. I also looked at what these trials were like, and it was just remarkable. So I especially knew well the case of Earl Washington Jr., who was an innocent man who was wrongly convicted at a capital trial in 1984 in Virginia. His trial was about a day long, and then another day for jury selection. And when I looked at these 1990s trials, just routinely you'd see trials, capital trials, death penalty cases, where the trial would be a day long, 2 days long, really brief trials. And basically, there would be no sentencing phase to speak of. Once the person was found guilty of capital murder, the defense lawyer would basically throw up his hands and not particularly do anything. Maybe call the defendant's mother, who would say, oh, it wasn't an easy household, but he was always a good boy. Or a prison chaplain to say, oh, he's doing great in prison. And the defense lawyer would basically just beg the jury, just please don't, I know you found him guilty, but just, you don't need to kill him. That all changed when you had an actual office that knew something about death penalty cases. The lawyers were paid very, very little when they were court appointed, although they did rack up quite a bit of costs in terms of filling out their team. These offices, though, I saw right away that they were all of a sudden calling twice as many experts as the prosecution. The sentencing phase was twice as long as it had been in the past, and the bulk of the witnesses were now being called by the defense. All of a sudden, the defense was calling witnesses and presenting a real mitigation case. And when the jury would hear a real mitigation case, they would typically reject the death penalty. And these are, death qualified jurors in Virginia, and they were turning away from the death penalty more often than not. So I thought that was a remarkable story. Stephen Bright has talked for years about how the quality of defense lawyering has radically changed now that there's an understanding that there are 2 trials here, and you need to actually investigate your client's background and put on a mitigation case, that is the trial. That wasn't how these court-appointed lawyers paid next to nothing in states like North Carolina, Virginia, were handling these cases in the 80s and 90s. They didn't know what they were doing. And once they lost at the guilt phase, they just sort of threw up their hands. These offices just made an enormous difference. I also wanted to see, murder rates have declined steadily since the 1990s. And maybe that homicides are up in a number of cities this last year, but in general, murder rates, we don't know why. Murder rates were going up in the late 1960s, early 1970s. In general, crime rates went up. And so the reaction, we must have the death penalty, the backlash to Furman versus Georgia was part of a tough on the crime move in American politics, which may have been about conservatives being in power, but it was also very much about a genuine fear of crime, which genuinely was going up. And we don't know why. Criminologists don't fully understand why crime went up in many other industrialized countries all at the same time. And starting in the mid-90s, in general, crime of all different types went into free fall. And that included murders. What is interesting to see here is that homicides have gone way down. And death sentences, there were never very many of them to begin with. And so even just looking at this, it can't be most of the explanation that homicide rates are driving this, because the vast majority of murders every year never turned into death sentences. You know, if you have 10,000+ homicides in a year, it's just, it was at its height, you know, 300+ death sentences in a year. Some other county level analysis. Fewer counties are sentencing people to death, but it's wealthier counties that are increasingly doing it. And, you know, there are theories about why that might be true. It could be that death sentences have become more of a luxury good. It's more expensive to hold these trials. They now, if you have real lawyers and they have experts and they're actually presenting the mental health history of the defendant, the social background of the defendant, if you're putting on a real trial, that simply costs more. We certainly have seen this, that it's wealthier and more populous counties that are still in the death sentencing business. So here's the average population, it's steadily gone up. I also wondered whether wrongful convictions have had some impact on death sentencing. You know, I've done work since I became a law professor studying patterns in DNA exoneration cases. And it's been pretty sobering, not only that so many people have been walked off of death row, exonerated by DNA testing or other types of evidence, but some of these cases were like the poster child death penalty cases, cases that, you know, laws were named after. Here in North Carolina, Leon Brown and Henry McCollum were the cases that were the focus of political ads against the enactment of the Racial Justice Act, which was repealed by lawmakers several years after it took effect. You know, the focus was on this horrific case, Leon Brown and Henry McCollum, where, you know, a young girl was brutally murdered in a field in the small town in which she had lived. And McCollum and Brown were exonerated by DNA testing after 30 years. Justice Antonin Scalia had highlighted the case, gone out of his way to highlight it in a different case, just to say that, you know, why do we have the death penalty? It's cases like this Henry McCollum's case, this brutal murder of this young girl. That's why we have the death penalty. Something needs to be done to brutal murderers like that. Well, they were innocent, and the evidence against them was extremely thin from the very beginning. It largely relied on these young men having supposedly confessed in detail. Their confessions were not recorded. The forensics evidence was not particularly good. They supposedly confessed in detail and signed statements after hours and hours and hours of interrogation by the local police. And it turned out they were innocent all along. So I wondered, well, I mean, certainly the public is now more familiar with the idea that there are innocent people on death row. And, you know, more than 20 have been exonerated using DNA testing. Another 140+ have been exonerated using other types of evidence. People now know that actually innocent people sit on death row in this country, and we may not know how many. Well, what I found was that there was actually no relationship between the decline that I was studying in death sentencing and the numbers of exonerations. And whether you lagged it and figured, okay, maybe exonerations impact a state, you know, over a few years, didn't matter. Instead, what I found was that the states with the most death sentences have the most exonerations. And so it was a different observation, that wrongful convictions just may be an inevitable byproduct of death sentencing. That states like Florida, that have some of the most wrongful convictions, most exonerations in death penalty cases, continue to sentence a lot of people to death, that you're going to have a lot of wrongful convictions as a byproduct of aggressive death sentencing. There's another example, Keith Harward in Virginia, who was exonerated, convicted based on a bite mark, and some dentists who said that the bite mark matched him. And his case, just like McCollum and Brown's, suffered from this intense pressure to do something about a high-profile murder in a locale where they needed to find someone. And so the evidence was twisted around to suit whoever became the likely suspect. McCollum and Brown were just young men. They were kind of slow. They were poor. They were black, and they were, you know, coerced into confessing. Keith Harward, they knew that it was a Navy sailor who had done it near the Navy base in Norfolk, Virginia. And they knew that the victim had been bitten when he was in a fight with his girlfriend a year later, and she scratched his face and he bit her arm. They were like, oh, we got a biter, case closed, that's enough. I have a new book, by the way, coming out next year, looking at how errors in forensics contribute to wrongful convictions, and just in general, all the different ways that the work that our crime labs do can go wrong, and how poorly we've addressed these problems with the use of unsound science in our criminal system. So that's what's coming next for me. I was just finishing the index for the book this weekend. I want to turn to what I found looking at race and death sentencing. So really unbelievable research has been done since the 70s on race and the modern American death penalty. And the most important work was done by the late George Baldus, looking at homicide, David Baldus looking at studies of Georgia homicides, incredibly comprehensive and powerful work, which the Supreme Court ultimately decided would not influence its decision about the constitutionality of the death penalty. And so the Supreme Court suggested that this type of white lives matter effect in death sentencing, that death sentences are far more common in cases where there's a white victim. They decided that even if that evidence was convincing in terms of its statistical rigor, that it would not be of any constitutional dimension. Nevertheless, researchers, including David Baldus, replicated those results in basically every study, every state where they were able to study death sentencing patterns. And so there have been dozens of studies now showing this powerful white lives matter effect. Now, to be sure, that means that since most murders are committed within race, that there are perhaps fewer Black defendants sentenced to death than there otherwise would be if it was a race of defendant effect. But the idea that death sentencing hinges so powerfully on the race of the victim, and that race plays such an outsized role in death sentencing, extremely troubling. And yet it only results in relief at the local level if you have a state that has a racial justice act like North Carolina did for some time, and which is now retroactive, the North Carolina Supreme Court held to prior cases. So there is state litigation regarding these race patterns. We found the same thing looking at all death sentencing nationwide during this time period that we studied from 1990 through 2015. And what we found is that, murder rates were declining during this time, but that death sentencing was never particularly correlated with homicide rates. But there's a reason why, and that was that death sentencing, we found, had nothing to do with Black victimization for homicide. However, white victimization in a county, if there are more white victims of murder in a county, then we saw a close connection with death sentencing. The same white lives matter effect that David Baldus found in Georgia in his landmark study, and in the replication studies that they did in other states. And so I thought that was powerful to see this across the country. An effect that we saw, though, that was the largest in terms of all the different statistical connections we saw, was just the connection between having sentenced someone to death and then doing it again. And so we looked at just a county and having sentenced someone to death the year before, or once in the last 5 years, 2 years, 3 years, 5 years. We broke it down lots of different ways. No matter how we broke it down, we found this powerful inertia effect, that counties that were death sentencing counties were much more likely to keep being death sentencing counties, irrespective of their homicide rates, population, these other factors. There just seemed to be this powerful muscle memory or path dependency in death sentencing. Death sentencing counties were death sentencing counties because they were death sentencing counties. Now, it may be, anecdotally, there are prosecutors that were quite proud of the fact that they, as a matter of policy, sought the death penalty whenever they could. But that said, this path dependency, we couldn't tell whether it's the prosecutors, it could also be that jurors were especially open to the death penalty, or that judges were especially open to pushing capital trials forward fast. The defense lawyers could be particularly inadequate in these counties. Could be a combination of lots of different things. But we certainly saw that these county level effects really persisted over time. So I want to talk a little bit more about the implications of this decline. Despite that kind of muscle memory, some of the top death sentencing counties in our modern history are now not doing it anymore. Whether it's Harris County in Houston, Texas, or Philadelphia, the death penalty has retreated to some scattered counties around the country. And instead of seeing 300, 340 death sentences a year, we now see a few dozen. Most of those may never result in executions. And of course, there's a big chunk of death sentences every year that are in California where there is no death row. There is no way, a legal way to execute people. Very few of the people sentenced to death in the modern American era have been executed. The data on executions is also really interesting and disturbing, and is extremely racially skewed by race of defendant in terms of who gets executed in this country. And so there's more to say about that as well. But in terms of implications, what does it tell us that just having a trial office of lawyers that know what they're doing means the difference between life and death writ large across this country? It's terribly disturbing, and it also suggests some positive things in that, in these really horrific murder cases, the ones that prosecutors are focused on when they decide whether to seek the death penalty, having a lawyer there to tell the person's, well, really a team of 2 lawyers and some social workers, to tell the person's social background can convince jurors in even the toughest death penalty states to turn away from the death penalty. Jurors are turning towards mercy in places like Virginia, like North Carolina, where they never did before, because they're hearing about the mental illness, the substance abuse, the social background of someone who committed a horrific crime. And innocence is not an issue in most of these cases. Instead, it's the sentencing question. Is this someone who deserves the ultimate punishment? And you have jurors that are selected because they do not oppose the death penalty. Otherwise, they wouldn't be death qualified. And nevertheless, in one high-profile case after another, so many jurors reject death sentencing today. And I think that's remarkable. It may be that public opinion continues to change. It may be that there's a different attitude towards mental illness in this country. More people have family members that struggle with substance abuse, depression, one form of mental illness or another, and people increasingly perhaps understand that you don't kill someone for that, that they aren't blameworthy in the same way. But that has huge implications for the rest of our criminal system, because any given jail in this country has 30-40% of its population people who have serious behavioral health needs of one type or another. You turn to our prisons, enormous numbers of people struggling with behavioral health needs. We look at the 8th Amendment. Will the Supreme Court ever consider why the death penalty is declining and consider it to be more unusual? To consider the reasons why the death penalty rose and is now falling? I don't see the court doing that. There is basically one justice that has really engaged with these issues recently, and it's Stephen Breyer. I think we maybe have one other justice, Sonia Sotomayor, who would join, and that's it. In 2014, it looked like maybe there was some chance that the Supreme Court would engage in these issues more. I don't think that Breyer would have written this lengthy opinion getting into this research, citing a ton of law professors, citing my work, citing everyone else's work. I don't think Breyer would have written that lengthy opinion unless he thought that Justice Kennedy might be coming around on the death penalty. That was not to happen. Some other features of the death penalty decline, which should cause us to think differently in a different way. This is what happened when Texas adopted life without parole. In general, I studied, did life without parole adoption have something to do with states? All of a sudden, a jury could put someone away for life. They'll know this person, this killer will never walk the streets again. So maybe we don't need the death penalty anymore. I found very weak evidence that adopting life without parole actually affected death sentencing patterns in states. But it also did something else. In Texas, you can see the death sentencing was already declining in Texas. Starting in the late 90s, like in lots of places, death sentencing began to decline. It's a little uneven year to year, but death penalty was already declining. What happened when life without parole was adopted wasn't some new trend towards fewer death sentences. What happened was Texas prosecutors went wild with life without parole sentencing. And that's come down in a little bit in recent years. But in general, we now have more than 10 times the people serving life without parole sentences in this country than were ever on the largest death row in this country. And so we now have 50,000 plus people serving life without parole. Just a massive number of people, many more people serving virtual life without parole sentences where there is no possibility they will realistically be paroled. And in general in our prisons, it's just a larger group of people who have no legal possibility of rehabilitation. There is no possibility of release. And so I'm not sure that we can tell ourselves that we've become a more merciful country in that we've turned away from the death penalty when we've also turned towards imposing 10 times more life without parole sentences than existed in just a couple of decades ago. All during the same time period when murder rates are steadily declining. Like there isn't all of a sudden a need for, what do we do with 10 times more murderers? No. When you look at the patterns in these life without parole sentences, as part of my center, we've done some studies of juvenile life without parole sentencing. We have a study of adult life without parole sentencing coming out later this month. It looks a lot like the death penalty, where there's a handful of counties that explain the bulk of the sentences, where these people don't look like they are the worst of the worst. Plenty of the juvenile sentenced to life without parole in North Carolina were under a felony murder theory. They weren't necessarily even the most culpable person involved in the particular act. And so it is easier to sentence people to life without parole, but it reflects the same kind of prosecutorial discretion where you have certain counties that just happily impose large numbers of severe sentences, and most others don't. So I'll stop there. There's a little website for my center and some of the work that we do. That was at our first launch event a little while ago. I'll stop the screen sharing too so that I can come back onto the screen with the Duke campus behind me, the campus that I don't really see anymore because everything is remote. So I'd love to stop and answer your questions. I don't know if any of you have read the book. It's hard to find the time and space to read books these days, but hopefully my tour of the book gave you an idea of what I was doing with it. And I continue to update the data and think about other ways of working with it as well.
Thank you, Professor Garrett. I thought that was amazing. As I thought the book was amazing, I think the book is amazing. I didn't introduce myself earlier. I'm Marshall Dion of Pennsylvanians for Alternatives to the Death Penalty. I'm on the state board and active in the Pittsburgh chapter. And thank you so much for being with us. I have, I have a whole lot of questions, but I'll try not to monopolize all of our time. I will ask about one thing that seems interesting to me for the times that we're living in. Race in the criminal justice system is sort of a pretty big issue in our society. I know that the Supreme Court rejected an equal protection challenge in McCleskey versus Kemp back in 1984. But Chief Justice Roberts, in particular, has seemed pretty sensitive to issues of race discrimination in the criminal justice system over the last few years, allowing allowing impeachment of jury verdicts when race discrimination is an element of the issue that's involving the impeachment of the jury after a trial, and also the decision out of Texas where the defense put on an expert who said that black people were more dangerous than white people, and Chief Justice Roberts said that some toxins can be very dangerous in even small amounts. And so I was wondering what your thoughts are about sort of revisiting a challenge to the death penalty in the United States based on race discrimination grounds, even though the court looks like it's going to be as conservative as it has been in 100 years.
Yeah, I do think, some of the most egregious constitutional violations will continue to come to the Supreme Court in death penalty cases. This is where we see the most severe prosecutorial misconduct. This is where we see some of the most severe race discrimination. These are the high pressure cases with gruesome crimes and aggressive prosecutors that want to do everything that it takes, and they have more resources at their disposal. The defense may have nothing, but they will be trying to do every kind of forensics test. They want to show the community how tough on crime they are. And we have seen Justice Roberts and some of the other conservative justices come around here and there where there is egregious race discrimination, but always, these opinions are always one-offs, right? They're always highly individual facts. They tend to be written in a way where they certainly don't create new law in terms of warding off race discrimination in jury selection or in expert testimony. They tend to be highly confined, narrow opinions where the justices can say, we did something about a bad result in one case, but they're not exactly making a new discrimination law, anti-discrimination law. And so they are important. They're in some ways symbolic, but they aren't actually tackling the reasons why discrimination so routinely plays a role in jury selection or in prosecutorial discretion. That this court was never going to, whether it was 5 years ago or 5 years in the future, revisit McCleskey or look into prosecutorial discretion or look into the question whether bias plays a role in who gets sentenced to death and who gets executed in this country. So I don't think systematic challenges are going to have a happy home in the Supreme Court. In some state Supreme Courts, yes, though. And so we saw that in North Carolina with our Racial Justice Act. California just passed a Racial Justice Act. And so hopefully the racial justice movements across our country will play a real role at the local and state levels in reconsidering the use of the death penalty. I think it's also striking that there is a space now for conservative judges like John Roberts and conservative people to be quite anti-death penalty. Like, the death penalty is not the hot button issue that it was in the 80s and 90s, in the same way that the criminal system isn't exactly the same hot button issue. When I've done some surveying of people on death penalty attitudes, I found that actually the people most against death sentencing were both the most liberal and the most conservative people that I've surveyed. And that others kind of in the middle are just sort of potentially open to it, potentially not. And so I think that, everything is polarized in American thought and politics these days, but the death penalty kind of isn't. And so it doesn't give me great hope for what our courts might do, but maybe the fact that you could have someone like Chief Justice Roberts write opinions here and there correcting injustices in death penalty cases says something about how thin the support is for the death penalty among lots of institutions, including some pretty conservative ones.
I think Bob Lindsay has a question. Bob?
Oh yeah, I see in the chat asking whether intoxication or being under the influence of drugs would be considered mitigation. Sure, and so anything can be mitigation, really. And so basically the way the Supreme Court put it when they brought back the death penalty, the concern was that death sentencing was really rare and that there was no particular relationship between who was sentenced to death and the seriousness of their crimes. You know, prior to the 1970s, across the South, you had the death penalty for sexual assault. And that was not just a race of victim effect. You had Black defendants routinely sentenced to death for rape. When the Supreme Court brings back the death penalty, they say, no, it can't be rape anymore. And you can't have an automatic death penalty for any particular category of offense. It has to be murders. And there has to be an effort to make a case to the jury that this is one of the most serious murders. It can't just be any old murder. And so the prosecution would have to show that this murder had something aggravated about it. And states had to set out what could make a murder an aggravated murder. A lot of these statutes are very, very vague and say things like, is the murder heinous, atrocious, or cruel, or with malice, or whatever. Or they have itemized death qualifiers like it's a murder, it's a killing of a police officer, or a murder accompanied with kidnapping or sexual assault or terroristic devices and the like. And in response to that, though, the defense can present anything, really. And so mitigation cannot be itemized. It cannot be cabined. The defense can show anything that it thinks it would be valuable for the jury to consider that, okay, even if this person did commit a murder that was aggravated in one of these itemized ways, is there anything that makes this person less than fully blameworthy? And so it could be their social history, it could be mental illness, it could be traumatic brain injury, it could be remorse, it could be any number of different things. And so that actually gives the defense a quite wide scope, which is why it was so disturbing and horrifying that, you know, in the 70s, particularly by the early 90s, when everyone understood what a sentencing phase was and what you're supposed to do, that you had defense lawyers that would just say, I don't think I have anything. You know, just please don't execute my client. And it was that just embarrassingly poor defense representation that started to attract the Supreme Court's attention. They didn't do too much about it, but they did start to issue some rulings. But it caused the bar to become better trained and organized. And there was some threat of litigation just how disturbing it was that you'd have these brief summary trials cause some states, to set up these capital defenders' offices that had such a dramatic impact. I see another question about the drop in rural counties. So there's been a really striking drop in rural counties in states like Virginia, where there are these capital defense offices, states like North Carolina. In Texas, there's a rural capital defender. But there are other states where there isn't any office like that, and where rural capital representation may not be that great, where you still seen this drop in rural death sentencing. And so some of it also has to do with just the decline in murders. There are just fewer murders in rural places, and also cost. That even in these rural counties, even if there isn't a good office that's handling death penalty cases, it is clearer now that you have a right to access experts to put on the social history. And even if the lawyers don't do that great a job of it, it is extremely expensive. And so the combination of that expense and the chance that if the lawyers do get their act together, you lose, like as was happening so often in Virginia, where prosecutors would spend millions seeking the death penalty and they wouldn't get it. That combines to make for a real decline. I mean, I live in Durham County here in North Carolina, neighboring Wake County. They went about 8 years, 9 different capital trials where they sought the death penalty and lost. Expensive trials, one after another after another. And that's not a rural county, that's a big county. It includes, you know, the state capital, Raleigh. A little over a year ago, they did finally get a death sentence, but it had been a long time and a lot of trials where they had just a terrible record of seeking the death penalty. And that's, at some point you see counties they just stop. If they haven't gotten a death sentence for years and they keep losing, you're not going to have a team of prosecutors that's really excited to bring these trials. They don't have a winning record anymore. And it's enormously costly. What is not so costly is using the threat of the death penalty to get life without parole sentences. And so you've had plenty of counties do that more aggressively. And so we have this enormous rise in life without parole sentences, even as death sentencing has reached record lows.
Can I ask something? I'm in an undergrad activist think tank at my school, and I feel like I'm struggling to get other people in the think tank to care about death penalty issues. And I've used stats and try to convince them that that we should hold an event that educates people on it, or maybe do a Just Mercy screening or something, because I know I went with my dad to Just Mercy, and I got him to rethink his views on the death penalty. So how do I just get people to care? What do you do to get people to care and say this is important? What's your go-to strategy?
I mean, in some ways, there are so many pressing problems with our criminal legal system right now. I'm fine if people choose their focus. I also do a lot of work on wrongful convictions. If people only care about the death penalty because they know that there are innocent people on death row, that's fine. And there's a lot of work to do on behalf of wrongfully convicted anyway. If it's people don't want to see individuals killed by the state, that's an urgent issue right now. And if people figure, well, the death penalty, there's less death sentencing going on right now, maybe it's not a topic really, if they could read my book and say, well, death sentencing is declining on its own, we don't need to do anything. You don't need to abolish the death penalty in states like Virginia where no one gets sentenced to death anymore anyway. Well, we have people dying of COVID in our prisons across this country. Our prisons are increasingly made up of people who are elderly. And whether you're on death row or it's the vastly larger group of people serving life sentences or life without parole sentences, the idea that you could die because of the state and because of a severe sentence, which would not be imposed in any other Western country, that's a pressing issue right now. We have a pandemic that's hitting all of our prisons and our jails. And so if it's the lives of people in custody that grips people, that's a gripping issue right now. And if it's severe sentencing just in general, why do we impose sentences that we never did in our history and that no other country does in the world? If it's mass incarceration, if it's race discrimination, death sentencing is an exemplar for how race discrimination affects the criminal process in our country. Now, that said, if you want to see racially discriminatory outcomes, you can look at police use of deadly force. You can look at jail and the cash bail system. There are a lot of places to look. And I think it's a healthy and good thing if people look at lots of aspects of our criminal legal system and are horrified by many of the things that they see. But the death penalty does really crystallize a lot of these issues in a stark way. And so it's an important place for people to look. If people look at the death penalty and decide, I just want to focus on the population of my local jail during COVID, great. If people look at the death penalty and say, wow, public defenders can save people's lives, I want to be a public defender and do all sorts of different cases, great. Plenty of people may watch Just Mercy and decide they want to be a civil rights lawyer and do civil litigation on behalf of people who are the victims of discrimination. Someone who teaches law students, I wouldn't necessarily tell a student, I want you to be, you should really go into death penalty litigation, because there are fewer death sentences. There are fewer lawyers needed to do that work. That's a great thing. We hope to abolish those jobs along with the penalty itself. I don't think there's any secret to how to get people interested in this issue as opposed to others. I think it's an amazing thing right now, actually, that so many students are not just focused on the death penalty. They're not just focused on wrongful convictions and Innocence Project stories. That people are actually focused on the stuff that no one learned about in school when I was a student, like a cash bail or collateral consequences or felon disenfranchisement, barriers to employment, reentry. Those were all the issues that were quite hard to get people's attention on. And the focus had tended to be on the death penalty and on wrongful convictions, the most serious criminal cases and the most serious errors. So I think it's wonderful that people are looking at the regular, everyday misdemeanors, bail, and whatever you can do to get people focusing on what happens every day in our criminal system, all the better.
I had a question, Professor Garrett. Do you think that in light of recent events with George Floyd and Breonna Taylor, that this increased police scrutiny might lead to a change in procedure with police in terms to the prolonged interrogations and police being able to lie to suspects, which often, as you mentioned, lead to these false confessions currently going on?
Yeah, there are a lot of, half of the DNA exonerations in death penalty cases involved false confessions. There's a lot of pressure to do coercive interrogations in death penalty cases, because if there's no witness, the only way you're going to get someone to say something about what happened is if you can get your suspect to confess. And so there's a lot of use of informants, a lot of the person confessed in the jail cell or something, or just directly police putting pressure on someone to confess in capital cases. And so, in general, I suspect that the concerns about race and police misconduct will affect how people look at evidence in all sorts of different types of cases. Right now the public conversation, though, is more about police killings on the street. And I understand why, right? There are not very many executions each year. The executions have declined just like death sentences have declined. And nevertheless, there are an enormous number of people, disproportionately Black, who are killed outright on the street. And the police brutality and racial profiling has been a incredibly powerful subject for public concern, leading to major unrest, major protest movements for decades now. And that said, it's also a dispiriting topic because death sentences have declined. Prosecutors don't get the death sentences that they try to get, increasingly. There are a lot of good reasons to be optimistic. Certainly more states have abolished the death penalty, although not any of the states that were big death penalty states. We can point to some progress, at least. We cannot point to progress on police use of force, really. The number of deadly uses of police force have remained extremely high in this country for years. When I was in law school, the big cases were Amadou Diallo, Abner Louima. There were the Rodney King riots in the early 90s. Major protests throughout the country in the early 80s, early 70s, mid 60s. Or you go back every decade, there are just massive amounts of police violence. And we haven't seen any change. And so it's, I think there's, there should be a connection, but I'm not sure that there is one. And the problem of policing in this country is a bigger and in some ways more intractable problem, which I think is why people don't feel like they can get recourse in the courts and why we have some of the largest protest movements in our history. Like in North Carolina, capital litigation is going really well in the courts. There are not very many death sentences, and the Racial Justice Act now applies retroactively. Like, there's a lot of work that lawyers can do to make a lot of progress. But in terms of litigation to address police use of force, there's very little recourse.
Can I ask a sort of extension of that question? Can you hear me?
Oh, yes. Oh, yeah.
Oh, sorry.
I was just waiting for the question.
Oh, yeah. So to what extent, if any, do you think because you mentioned how, the United States hands down harsher non-death sentences than any other Western country, how we have these issues with police misconduct that aren't as pronounced in most other developed countries. To what extent do you think the retention of the death penalty sends a signal to actors within the system that it's sort of okay to treat people's lives as though they're not that important? Because we do have this, ultimate penalty is you are killed by the state, so it sort of follows that the lives of people designated as criminals aren't to be treated with that much sacredness that you might treat other people's lives. Do you think the death penalty has an impact on that, even a marginal impact?
I don't know. I mean, certainly, like, culturally in prosecutors' offices, right, there are these remarkable examples of nooses being given out to prosecutors who secure death sentencing. Like, there is a bloodthirsty culture that goes along with seeking the ultimate punishment. But that said, it's not like the states without the death penalty really showed how much they care about the lives of their jail inmates or prisoners, during COVID. It's not like there's like the non-death penalty states have better health care and are really thinking about reentry and are thinking about people in prison as people. I just don't see a lot of evidence of that. Certainly the most hardcore death penalty states in the South do have higher incarceration rates, do have, a history of whether it's lynchings or Jim Crow enforcement and brutal policing. But there are many, many northern cities that have terrible patterns of whether it's cash bail abuses or police use of deadly force. We have national problems with mass incarceration. And I don't see the evidence that these problems in terms of our indifference to the lives of people caught up in our criminal legal system are worse in our death penalty states. It certainly is the ultimate symbol that we believe that the lives of people who are convicted of certain things are forfeit, but we treat people like that, we treat people like that in our jails where they haven't been convicted of anything yet.
I see another question in the chat, and I was trying to multitask, so I'm not sure if this was covered. It's from Martha, and she says, you made the statement that the dirty secret among prosecutors is that the death penalty hinders the fight against crime. How so?
Well, I don't really remember that quote well from the book, but I think that the tenor of those types of comments where prosecutors have sometimes candidly said, like, we don't need this, we don't think it helps, have been to the effect that death penalty trials are really expensive, that you could hire 1,000 cops for the cost of keeping the death penalty in a state. You have states that have spent billions on all of the appeals and the trial representation, on maintaining the death row itself, all the different accoutrements that you need to run even like a not very fair capital system. And so even in law enforcement and prosecutors' offices, they've said, like, we can do things with that money that would far better accomplish public safety. And so there's increasingly skepticism that the death penalty does something for public safety. People used to think, well, maybe it deters killers, but obviously there's no evidence of that. And people who commit murder are often mentally ill or acting in the heat of passion. They're not thinking about what sentence they might get, nor the difference between a life without parole and a capital sentence, which it's not clear which some people would pick regardless. So if it's not going to create some kind of a deterrence, if it doesn't send some message that actually accomplishes public safety, then what's the public safety benefit of having it? And more people who care most about public safety in the sense of stopping crime are skeptical that the death penalty accomplishes that purpose.
I'm just giving folks a little breathing room in case there are more questions.
I have another, if I can jump in.
Sure.
I should go after maybe one more. I have to
Okay, we'll let you.
make sure.
You know, federal capital trials have really good defense lawyering, unlike most state capital trials. What's the Fed's winning percentage? Is it as low as it is around the country?
I have to check. I know I talk about it in the book. I mean, it's always been remarkable to me, you know, just how incredible the training is at our federal defender's offices. Those are amazing jobs, amazing people. And the federal capital defenders have really led, not just in terms of, you know, how well they have defended clients in federal cases, but how they've set standards and done trainings and really helped to educate the capital bar in many other places around the country. I mean, there are plenty of states which have incredible offices that also are a model, but you know, the federal defense offices are so consistently good. And what has been impressive is that, you know, when we've had attorney generals that have pushed for more death sentences, they mostly haven't gotten them. You know, our current attorney general can appear tough on the death penalty by pushing some old cases towards execution, and there have been several executions. But federal death sentences are not common. And even, you know, when you had Ashcroft saying, you know, we're going to seek the death penalty right and left, even in states or jurisdictions where there is no death penalty, like in Puerto Rico, mostly really didn't happen because, again, there's this confound that the people that prosecutors identify based on the facts of the crime as, well, this is the worst of the worst. This is, you know, someone who committed, you know, a particularly atrocious murder. The people who do those objectively atrocious things are subjectively some of the most mentally ill people. You know, the people who do those things are often not in their right mind. And prosecutors may not know that if they're not experienced when they bring charges, but once they see the defense case, once they see the mitigation, it can be quite sobering. I talk in the book a lot about the Aurora Theater shooting, where, and I've talked to the prosecutor some about the case. He spoke to my students. He was saying that, you know, this is the worst mass shooting in Colorado history. That it was so many mass shootings ago that some people here probably don't even remember it. It was, you know, this Batman showing in a suburban movie theater, and this young guy, Holmes, you know, walks in with every kind of weapon and kills an enormous number of people, wounds, you know, 60 something more. And the prosecutor, I think you could understand how the prosecutor, like, if we have the death penalty in Colorado, it's got to be for this case and not any other. Like, this is the worst shooting we've ever had. What's the death penalty for if not this? But, you know, the person who does something like that, he was severely mentally ill, just had horrible delusions, was just consumed with homicidal fantasies. I mean, it takes being consumed with homicidal fantasies to do something like that. Like most of us, you know, couldn't, you know, shoot at like 60 mice in our basement or cockroaches or anything, much less people. Like to kill that many people or to try takes a really problematic connection with reality. And the jury saw that right away, right? It didn't take them long. They didn't deliberate for very long. After, you know, $10 million or so were spent on this trial, you know, it was quite clear that this person had severe schizophrenia and had snapped. And you don't, you know, to execute someone because of mental illness, that doesn't sit right with most people. So, and you see that time and time again, that there's this confound that the worst crimes are not committed by the worst people. And it really does call into question our whole system of punishment and what it means to punish using the criminal system. I think that's another way that the death penalty stands in for what we do in so many cases. And where, by the way, in minor cases, I talk in the book about how the death penalty is also a model. You know, you don't hear about someone's social background if they're convicted for the third time of shoplifting. Do you have a mitigation expert come in and say, like, I'm an expert, but come on, this guy is homeless. That's why he keeps getting something to eat and not paying for it from the convenience store. Does a judge hear about that? In death penalty cases, where it is done right, you actually hear about that. And it's legally part of the job of the jury that they have to listen to that and decide, just on this question, life or death, which is a horrible question to put to a jury. But they do have to actually think about this person and as a whole, only in the context of deciding whether to spare their life. But we don't do that normally in criminal cases. We don't think about that in terms of, well, should they just get a suspended sentence and we should find them some housing? Or should we sentence this person to 4 years and not 10 years? And so this idea that mercy plays a role in this very constrained and disturbing way does raise these questions. Well, why isn't there a place for mercy in regular criminal cases? Or if there is, why is it done in the way that it's done, where it's highly cabined, or only certain people are allowed to do it? Maybe just the prosecutor can think about it if they want. So
I have a sort of gambling question for you. If you were a betting man, how do you think that the death penalty is going to finally end in the country? Do you see it as a state-by-state legislative or state-by-state court or the Supreme Court?
I kind of tend to think that it's going to be with the whimper, not the bang, like what's happening in Virginia and North Carolina, where just death sentencing fades away, and at some point everyone decides, why should we keep this on the books? We're not using it anymore. That's what's happened in the states. The states that have abolished the death penalty, it's been after some time during which no death sentencing was really happening. And so at some point everyone says, why?
Okay, thanks.
Yeah.
Well, thank you, Professor Garrett. We are very, very grateful for
Absolutely.
you to have given us.
Great to meet you all. Yeah.
And thanks everybody for coming and celebrating World Abolition Day with us.
Absolutely. Tell us the name of your new book again, please, Professor Garrett.
Well, sure. Yeah, it's called Autopsy of a Crime Lab. It's about all the different ways that errors can occur with forensic evidence.
I'm looking
It's
forward
like
to
a march through all the different ways it goes wrong, from the crime scene to the crime lab to the courtroom.
Terrific. Thanks. Maybe we can talk to you again after we've had a chance
Come
to
back.
do that. I appreciate it so much. Thank you. Good night, everybody.
Take care, everyone.
I was trying unsuccessfully to multitask.
Oh, you got it. I'll see you later. Thanks, Kathleen, for hosting this.
Thank you so much. This was really nice.
It
Take
was.
good care.
All right,
Bye.
you too. Bye.